Thank you, Your Honor.
Thank you, Mr. Lynch. Mr. Santakis?
Thank you, Your Honor. I'll keep it brief. I'd just like to address a few of the comments that counsel made. First, with respect to the first public records request, counsel stated that it was denied because the requester's true target, that was the words he used, true target, were the email addresses. First, I'm not aware that that's true. That's not included in any of the briefings. And as I noted, the case law is quite clear that anybody's purpose or motives for making a request is irrelevant. So I'm not sure what counsel is trying to accomplish by pointing out that the true target are email addresses.
Well, and setting aside whether it is or is not the true target, does the government have to provide all of those email addresses to anyone who asks? I mean, is there a certain amount of personal information of folks that live within the district that isn't protected from disclosure?
I'm not sure I can answer that question specific to the district. My understanding of the public records laws is that emails to a government body are disclosable, including the email address of the person who sends the email or who receives the email. Though we certainly recognize that there may be countervailing interests of confidentiality or privacy rights and things like that in certain instances. Though my understanding of the case law is that that only applies if there's some demonstrable harm to the person whose name would be disclosed. Just anecdotally, my own experience, I've seen plenty of public records from government bodies that include email addresses. There's no particular reason why they should be excluded. If the court is concerned that privacy interests may be implicated, we'd be happy to allow the court, or we'd be happy if the court suggested an in-camera review to check for redactions or whether redactions ought to happen. But our general position is that the email addresses should be disclosed along with the emails. Anyway, that's that on that issue. With respect to the ombudsman, counsel responded no to your question whether the ombudsman opined that 1096s should be denied. My understanding of the ombudsman's opinion is in fact that they should be disclosed. I believe that both myself and counsel included the ombudsman record in some of our filings, specifically finding that there's nothing in the federal statute that would preclude a 1096 form from being disclosed. And I'd like to come back to the 1096 in just a moment. With respect to number 3, counsel indicated that a dollar amount should be redacted, but not the names of the person who performed the work and things like that. And the same thing for number 4. So I want to discuss the ombudsman opinion as well as everything related to 1099 forms and 1096 forms, just in one fell swoop, because I think the same principles apply to all of them. Your Honor, just to be clear, a 1096 form is basically a tax cover sheet. It provides the filer's name and contact information, employer identification number, the total number of forms being filed with a tax return, the total amount of federal income tax withheld, so that's a monetary figure, the aggregate amount reported, another monetary figure, and the type of forms that are being filed with the tax return. So that's what we're talking about in terms of the 1096. 26 U.S.C. Section 6103, I would submit to the court, opposing counsel is at best reading that statute in an overly broad manner. It does not preclude the district or any taxpayer or any tax filer from disclosing its own 1096 form. 6103 precludes disclosure of returns and return information obtained by tax agencies such as the IRS and state auditing companies, state auditing departments and things like that, who receive other taxpayers' tax returns from the IRS. So it only governs agencies, it only covers documents obtained by tax agencies for the purpose of determining tax liability. There's no fair reading of that statute that it would apply to the person or to the district actually filing a return. In other words, it governs what government can and cannot do with information it obtains, not what the filer itself can do with that information. Anyway, moving on, nothing in Arizona or federal law prevents the district from disclosing its own 1096 forms. No information ought to be protected under that statute, including the total amount of income reported filed with a 1096. That's clearly a matter of public interest. The amount of money that a government entity receives from taxpayers and constituents